Welcome to our myth-busting segment, the myths that disability insurance policyholders believe about ERISA and individual disability insurance, and the truth. Look, I think my job is to be a myth buster so that you understand your ERISA and individual disability insurance policy, the ERISA and individual insurance claims process, and the games that disability insurance carriers play to delay or to deny your benefits. You might have even heard from neighbors, friends, or even lawyers and insurance agents myths about the disability insurance claims process or policies. And I hear those myths every day. So we're going to bust some myths. Today's myth is if your employer tells the disability carrier that you're disabled, you've won your own occupation claim. So this is how it goes. Many times I get a call that goes like this. I'm having trouble doing my job, and I'm starting to make mistakes. I just got a bad review, and I'm afraid I'm going to get fired. Or my supervisor's been working with me and just came to me and suggested I go on FMLA leave or use my sick time, but I think it's just a matter of time before I'm going to have to quit. What should I do? Well, let's start out by taking a deep breath, and you should do what I suggested in the first segment. Determine if you have short-term disability coverage, get a copy of the plan description and read it cover to cover. Outline the policy or the plan so you understand the terms, particularly how your policy defines the term occupation. Ask whether your doctor is going to support your claim and be willing to fill out forms. Tell your doctor about your occupation and the specific problems you're having, and look at those medical records and see what it says about your disabling medical condition and your inability to do your own occupation. So the answer to this myth starts with, I think, talking about the definition of occupation. What does your policy say? Is the term occupation defined to mean how your occupation is performed in the national economy, how it's performed based on the Dictionary of Occupational Titles description, which, by the way, hasn't been updated in 35 years, how your occupation is performed in the local economy, or how it's performed specifically for your employer. Because you've got to prove that you can't do your own occupation based on that policy definition. So I want to be working backwards. What is the definition of occupation? And I want you to understand what it is we have to prove about your inability to do your own occupation duties. So when you file a claim, the disability carrier is going to ask you to fill out a form that asks questions about your work activities. Now, I don't think these forms ever accurately ask the right questions because they really don't want to know the right answers. So I always want my clients to do their own version of what the occupational duties are, and ultimately explain why they can't do those duties. Now, the carrier is also going to contact your employer, and they're going to ask for your job title. They may even ask for a copy of your job description. And there are many, many times when the employer's occupational description doesn't match the reality of what it is you're doing. And as a result, the disability carrier will misclassify or mislabel your occupational duties and deny your claim because they thought you were doing something different than what you were actually doing. Now, I think that as you're preparing your description of your occupational duties based on the definition of own occupation in the policy, that you think backwards. Well, what do I mean by thinking backwards? What is it that you can't do physically, psychiatrically, or socially? And make sure that you describe those duties even if you aren't asked to. So now that we know what the definition of own occupation is, and now we know why you're having particular problems, the question becomes, does your doctor support your claim, and do the medical records even mention, much less discuss, the physical, psychiatric, or social problems you're having? And as I've said many times before, if not, find another doctor, and you're going to have to delay your claim until you can get a doctor who understands the disability claims process and is willing to support your claim. This is crucial that you do that now and not later. And why do I say now? Because look, If you're actually having problems doing your occupational duties, as some of the calls are that I get, you can get terminated. And if you get terminated, you're going to lose your disability benefits, your life insurance benefits, and your health insurance benefits. It's gone. Poof, it's gone. So unless you were working while you were disabled and had an appropriate reduction in your wages or no wages at the time you were terminated, you have no coverage and no claim. Now, if you smell furlough or you smell a termination in the air, get your medical records in shape and have your doctor take you out of work before you get fired or furloughed, because you want to apply for your short-term disability benefits before any of that happens. Now, your employer may be asked if they support your claim, or they may be asked, or you may ask them to give them a letter saying that you're disabled and you can't do your occupational duties. Well, unfortunately, that doesn't mean the carrier is going to agree and send you a check. The carrier is going to look at the definition of occupation and not what your employer says your occupation is and whether you can do it or not. Now, certainly the support of your employer will help, but it's not going to mean that you're automatically going to get your benefits. If the definition of own occupation is the occupation is performed by the employer, then I think that that's going to be helpful. But it also can be dangerous if there's a disagreement between you and your employer about what your occupation is and your duties. So I think it's best to be on the same page with your employer, your supervisor, the HR department, about your occupational duties before you stop working and apply for benefits. So the truth is, in my view, unless the definition of disability is an inability to perform your own occupation as it's performed for your specific employer, the disability carrier doesn't care if your employer says you can't work or do your own occupation. Next week, we're going to take on the next myth, myth number 4. If your doctor writes a note that you're disabled, the disability carrier will overnight FedEx you, express mail, deliver to you personally, a check. In the next segment, I'm going to be answering questions that we've gotten from our listeners, so stay tuned. Well, the first question I've gotten is, my insurance company sent me a reimbursement agreement. Do I have to sign it? The short answer is yes. Why? Well, many disability policies will require that you apply for Social Security disability benefits, and if you don't, they're going to assume that you're getting those benefits, and they're going to deduct those Social Security benefits from your check regardless of whether you're getting them or not. But the disability policy has a specific provision in it that generally will say that if they are overpaid, they're entitled to reimbursement, and that is an enforceable right. Courts all across the United States have found that disability insurance carriers do have the right to be reimbursed. Now, there's a strategy behind the reimbursement. What do I mean by that? Many times when a person is awarded Social Security disability benefits, that coincides with a 2-year change in definition from their own occupation to any occupation. And guess what the carrier does? They deny benefits. And so I say to my clients, well, I want you to put that check that you got from the Social Security Administration for those retroactive benefits in a separate checking account, and we will deal with that as part of the appeal and ultimate resolution of your case. Now, some lawyers may disagree with me, and they may say, well, look, go ahead and spend the money, and if you dissipate that money into an asset that's not traceable or seizable, like a car, you're fine spending the money. Well, I would say to you that I humbly and respectfully disagree with you. And the reason I would disagree with that is because there is, for example, in the Middle District of Florida, in the Tampa area, a decision from a judge that said, okay, well, she dissipated the assets. She used it for her car insurance and food and rent. But by the way, I'm ordering you to pay those benefits that you owe her, but you get to deduct from her future benefits, that overpayment, in addition to reducing her benefits by the ongoing receipt of Social Security benefits. So, I mean, I think that spending the money can backfire in some cases. So that's my answer. So the next question that I got is, my insurance company says I can perform my own occupation, but they're using the wrong job description. Why? Well, we covered that in the myths section, and that is because they are looking at your description of your occupational duties or what your employers provided, and their in-house vocational rehabilitation counselor is doing an analysis of the occupation. And sometimes there's not a pure fit. And so the vocational evaluator will look at a composite of jobs and come up with a description that may have nothing to do with your actual occupational duties. On the other hand, there are times when the carrier's vocational evaluator will just absolutely misconstrue what it is you're doing and improperly classify it. And if that happens, guaranteed you're going to get a denial, and guaranteed you should appeal that decision, because I think that is something that carriers need to correct, and generally they do correct that once we point out the error. Next question, and the last question that I got, was, my doctor doesn't want to complete any disability forms. What should I do? Now, again, I think I've discussed this before, but what's important is that you need a doctor that will support your claim, and you need to find that out before you apply for benefits, because if you apply for benefits and your doctor doesn't support your claim, the carrier is going to say, hey, if your doctor doesn't support the claim, why should we pay benefits? And then they'll seize upon that, because they'll have their peer review doctors agree with your doctor that that you can work, and so the case is lost. And if the doctor doesn't fill out a form, then what will happen is the carrier can ask for an independent medical evaluation, which is not independent, or they'll have their liar for hire peer review doctors do their own hocus pocus analysis of your medical records and conclude that you can engage in some level of activity that would preclude them from paying your benefits. So the fact that your doctor isn't willing to complete any disability form plays right into the disability carrier's strategies in denying your claim. So I hope that you've enjoyed our podcast. That wraps it up for today. If you haven't subscribed to the show, please do so. And I appreciate it if you'd leave a rating or review for us. See you next week. Take care.